Lawyers have a duty to protect their clients' confidential information. But what if revealing that information is necessary for a lawyer to stay out of trouble? Can the lawyer disclose in self-defense without violating the ethical rules? The court examined that issue in Meyerhofer versus Empire Fire and Marine Insurance Company. The law firm of Sitomer and Porges represented Empire in connection with its initial public stock offering in 1972. Stuart Charles Goldberg, one of Sitomer's attorneys, assisted in preparing Empire's stock registration statement that was filed with the Securities and Exchange Commission, or SEC. Dietrich Meyerhofer and Herbert Federman purchased Empire stock and suffered losses after Empire's share price declined significantly. In 1973, Meyerhofer and Federman sued Empire, the Sitomer firm, and Goldberg for securities fraud in a New York federal court. The law firm of Bernson, Hoeniger, Freitag, and Abbey represented Meyerhofer and Federman. The lawsuit alleged that Empire's stock registration statement was materially false and misleading because it didn't fully disclose the compensation arrangement between Empire and Sitomer, including a large finder's fee payment. Goldberg had left Sitomer by the time of the lawsuit, and he wasn't served with the complaint. When Goldberg learned about the action, he contacted Bernson to get more information. Bernson explained the substance of the complaint, and Goldberg asked for an opportunity to prove that he wasn't involved in the compensation arrangement. As it turned out, during his time at Sitomer, Goldberg had been worried that Sitomer was potentially charging finder's fees and failing to disclose the fees in clients' stock registration statements, including Empire's. Goldberg wanted to disclose the fees, but the Sitomer partners disagreed. Goldberg ended up resigning from Sitomer over the disagreement. He'd also submitted a detailed affidavit about the fee issue to the SEC. After consulting with his personal lawyer and counsel for the SEC, Goldberg gave Bernson a copy of the affidavit to prove that he hadn't participated in the finder's fee arrangement. Based on Goldberg's disclosures, Bernson asked the district court to dismiss Goldberg from the action. Empire and Sitomer moved to disqualify both Goldberg and Bernson from representing Meyerhofer and Federman in the action, or representing plaintiffs in any action against Empire involving the same issues. The motion was based on Canons 4 and 9 of the Code of Professional Responsibility, which require lawyers to preserve client confidences and avoid the appearance of professional impropriety. The district court entered an order disqualifying Goldberg and Bernson and dismissing the action. Meyerhofer, Federman, Bernson, and Goldberg appealed to the Second Circuit.